Thank you very much for joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal. And Scott Legal is a full-service immigration firm. We handle all types of immigration matters, employment-based immigration, family-based immigration, and with a particular focus on investor-based visas and employment-based visas. So a few housekeeping items before we get started. With this webinar will be recorded, and you will be able to see this on our YouTube channel. We'll be posting it to our YouTube channel. So we do encourage you to access the YouTube channel and subscribe to the YouTube channel. And because we have many webinars, we usually have at least a couple of webinars every week. And then we also do other informative immigration videos that we add to the YouTube channel. The other thing is that if you have any questions, you can add them to the chat function or the Q&A function, and we will get to all questions. The other thing to comment on is that we'll be going through a number of different visa types. We'll be talking about whether, when someone has a non-immigrant visa or a temporary visa and they're moving to a green card or want to move to a green card. So we'll be speaking about a lot of different non-immigrant visas, and then we'll be speaking about a lot of different immigrant visas, immigrant meaning green cards. And for each of these different visa types, we do have distinct webinars that you can view. So we are going to go through the visa types relatively quickly, but you can actually sign up for a webinar that deals with that particular category in much more detail, or you can go to the YouTube channel and find the old webinars that we've had on those topics. We'll be sending you a copy of the presentation after the webinar. We'll be sending you a copy of the link to the video. And we'll be also sending you a link where you can set up a consultation. And then we also will be sending you a link where you can actually get and download our guides or immigration guides. For each of these topics, we have comprehensive immigration guides that you can actually download and get more information on the topic. So without further ado, let's move into the presentation. So the first thing I wanted to go over is really just how the green card system in the United States works, because it is a bit different from other countries. So the difference is that a lot of other countries have a points-based system, and the points-based system is such that the individual may earn points for different things like speaking the language, for their education, for their work experience, for their age, different things like that. And then when they get a certain number of points, they can apply for permanent residency or similar green cards in their country. Now, the US, unfortunately, doesn't have a system like that. Instead, what they do is they just have a list of green card categories, and if you're eligible for them, you can apply. And one key thing to keep in mind is that none of the non-immigrant visa categories, none of the temporary visas lead to a green card. And the criteria for the green cards, there's never been a criterion, or there isn't a criterion that indicates that looks at how long someone has been in the United States or which visas they've had in the past. That may be applicable for other countries, but not the United States. So the major green card categories are broken into family-based and employment-based green cards. And then family-based green cards are further broken out into immediate relatives and preference-based. We're going to talk about those a little bit more in the next slide. And then the employment-based green cards are broken out into 5 different categories, and we see them listed on the slide there. And each of those, except for EB4, the religious-based green card, we are going to talk about today. So under the family-based category, we mentioned that they're distinguished between immediate relatives and preference-based categories. And the immediate relatives are defined by statute, so it's not what we would necessarily think of an immediate relative. So we would think of a sibling as an immediate relative, but the immediate relative category would be, for example, a U.S. citizen marrying someone, so their spouse would be considered an immediate relative, or a child, a U.S. citizen over 21 that's sponsoring their parents. So those are those are the immediate relative categories. And the reason they're important is because they have a significant amount of benefit. So one benefit is that the green card is always available. So because in all the other categories, both in the employment-based and the preference-based categories, there are a certain number of green cards that can be issued every year. And once that number has been met, people go on a wait list, and the wait lists right now are extensive. So, for example, if someone is a U.S. citizen is sponsoring their sibling, that is in the preference-based categories, and it would take 14 or 15 years for the sibling to get any green card benefit associated with their petition, and that's a long time. Whereas in immediate relative categories, the green card is always going to be available. The backlogs, as I said, they exist in every single category because the way that the statute works is that the government says that for every single category, preference-based and under family-based and employment-based, then they can issue a certain number of certain number of visas or green cards by category and by country. So then once that is used up, so you might see countries that have larger populations like India and China, that sometimes their delays are even more extensive in these categories because they've used them up faster. But it does result in significant waits. And when we look at the employment-based categories next, we're going to see that the waits are quite extensive, even for categories that in the past have not been long waits. So the other thing to look at here is the process. And the process for green cards is either going to be a two-step process or a three-step process. So let's just talk about the three-step process because that'll cover the two-step process as well. So for example, under the immediate relative category, and we get a lot of people that are on visas, on E2, TNs, H-1Bs, et cetera, that may meet a US citizen and marry and then apply for a green card. And so, that happens in different categories as well. But the first petition that's going to be filed is an I-130, and then if the person's in the United States, then and that's going to be like part one of the process. And if the person is inside the United States, it can file an I-485, which allows them to file for employment authorization and travel authorization. So that would be part two of the process. Part two could also be if the person is outside of the United States, then they would be doing something called consular processing. And then part three of the process, and there are only certain visas where there's a part three, but for example, that example that I used where the person, a US citizen, is marrying someone, there's a part three because they actually get a conditional green card for 2 years. And after a 2-year period, they have to file another petition to prove that, again, that the marriage was legitimate and a bona fide marriage. So there's going to be either a two-step process or three-step process. Most are two-step processes, but there are some that are three. Perfect. So now we're going to move to the employment-based categories, and we're going to start with extraordinary ability. So just in terms of moving from a non-immigrant visa to a green card, what we see here is that people who are on O1 visas, so that's a non-immigrant visa, temporary visa, and they often move to a green card using extraordinary ability. We do see it in other areas as well, but usually that's the area that we see it in. And what this particular category asks, has the person risen to the top of their field? So, and they use these 8 criteria that are listed here to assess that. So one might be that they're judging the work of others. So you think of something like American Idol. American Idol is going to have judges that have already had commercial success and are at the top of their field. So they're going to be judging whether other people are great singers and different things like that. But it's not only, the category, things like American Idol. It could be that someone's deciding who gets investment and deciding between which proposals are best. It could be someone deciding which papers get published in a particular journal. So lots of different things that if someone has risen to the top of their field, then they would utilize that. Same thing with salary, that you might look at somebody who's an engineer, and if the person's making well over what engineers make in the field, and that could be something that shows that they've risen to the top of their field. And then finally, just one more example, the person could have received different awards, right, that show that people believe that they are at the top of their field, or they've been quoted in major media indicating that they're at the top of their field. So that is the first category. Definitely a very high bar here because it really is saying that you've risen to the top of your field. And even if you meet 3 of the criteria or 4 of the criteria, they're going to then take a look at a very subjective analysis. It's a 2-part analysis to make an assessment as to whether they just believe that you have actually risen to the level of extraordinary ability. So that's something that to keep in mind. So the next category we're going to talk about, it's the next employment-based category is EB2, national interest waiver. Now keep in mind that EB2 is broken out into two categories. It's EB2 national interest waiver or EB2 company sponsoring you for a green card. So when we are looking at national interest waiver, the first thing that we have to look at if we're looking under the EB2 category is whether the person qualifies as a threshold issue. And the way that they can qualify is either an advanced degree, which is a master's degree or higher, or a bachelor's degree plus 5 years experience, progressive experience, or qualify under exceptional ability, where they have to meet 3 of the 7 criteria that are listed under that category. And those are different from the extraordinary ability criteria that I just mentioned earlier. Now, let's just assume that the person has a master's degree and they meet this, so now they're allowed to look at national interest waiver, and now we get to the hard part, right? And the hard part is based on meeting 3 requirements that are from a case, and the name of the case is Danisar. And the first is that you have to show that the proposed endeavor has substantial merit and is of national importance. And the substantial merit one is usually quite straightforward, but national importance means it's on a much, much grander scale. So which puts this one at a very, very high bar. It could be that there's jobs, you could be arguing economic impact, but a lot of the time when you're arguing that, you're usually arguing something else with it as well. We've done national interest waivers for cybersecurity experts. We've done people counterterrorism experts. There are lots of engineers. We do lots of national interest waivers for different types of endeavors. The key thing to keep in mind is that it is a high bar, and it is something that the government is giving you a green card because they feel that what you're doing is so important to the United States. Often it's going to involve people writing expert letters, either explaining why something is nationally important or explaining the second criteria, which is that you're well positioned to advance the endeavor. That's going to look at your education level. It's going to look at your experience, but also how far along you are, because they really are interested in track record and they're not just looking at bright ideas. They're looking to see that you actually are going to be able to accomplish whatever it is that you've set out to do. And then there's the last requirement is that the government looks overall and says, well, we already have said that we believe that the labor certification process of protecting U.S. jobs is nationally important. So what are the reasons that we should give this person for a green card? And so we look at different things there. Now, this particular green card, a number of different categories we see, visa types that we see moving to this. H-1B, we often see people, but E-2, we do a lot of E-2 to national interest waiver petitions, so that's another area. Sometimes if someone's on an O-1 and they're doing something innovative, then often the EB-1 is a good category, but the EB-2 can be a good category as well. And they sometimes people that qualify for EB-2 also qualify for EB-1, so that's something to keep in mind. But definitely a category where we move a lot of people to a green card. So both the EB-1A and the national interest waiver, they're both 2-step processes, and they both have the ability, give you the ability to self-petition. So that is great. That's fantastic. Where you don't need, what that means is that you don't need an offer from an employer, so you can self-petition. And the 2 steps in the process are that you have an I-140, which is the petition that basically shows that you've either met 3 of the 8 criteria or that you've met the Danisar requirements. And then you're going to look at, first you're going to look at whether the category is current, and right now it's not. But if it is current, then you're going to be able to file an I-485 or do consular processing, depending on whether you're in the United States or outside of the United States. And again, if you are in the United States and you file an I-485, you're able to file a work authorization and travel authorization. So that's something that is very useful to clients. The next way that people move to a green card is getting sponsored. So someone can be on a TN visa, they can be on an H-1B visa, someone can be on an E3, O1, or they can be on, for example, an E2, and then their spouse can be working for another employer because they have the spouse can be working for another employer because they have work authorization, and then the employer decides to sponsor them for a green card. So here we have, this falls under the EB2 and EB3 category. So EB2 being for professionals. So if you're falling under the EB2 category, you still have to meet the threshold requirements that I was talking about earlier, either a master's degree or higher, or exceptional ability, or bachelor's +5. And this does require company sponsorship. So, and it's a three-step process where the first part of the process is that you are doing something with the Department of Labor, showing that you can't find a qualified U.S. worker. So you're determining what the salary should be for the job, and the Department of Labor is doing that in conjunction with you. You are going through a recruitment process and making sure, again, you're doing everything to show that you can't find a qualified U.S. worker. So then when you look at this again is a two-step process where you're filing the I-140 and then I-485 or consular processing, depending on whether or not you are inside the United States or outside the United States. So another area that we process a number of different green cards, moving people from non-immigrant visas to green cards, is with respect to EB5. So EB5 is an area where you can either do a regional center or you can do a direct investment. And the difference between the two is a regional center is much more passive. So it might be, for example, a hotel chain that's building a large-scale hotel, and they want to attract a number of investors. And they utilize the EB5 program to raise capital. They're going to do the job creation, which we'll see is a requirement as well. Or it could be a direct investment. It could be someone starting a gym or they're starting their own business. And as they're starting their own business, then they may want to invest the requisite amount of funds and create the U.S. jobs themselves. So the requirements. So you're going to have to invest in the, unlike the E2, because we move a lot of people from E2 to EB5 after they make additional investment, is that you have to invest either 800,000 or 1,050,000. And the amount is going to depend on whether or not you are in what's called a targeted employment area. And a targeted employment area is going to be either an area where the unemployment rate is 1.5 times the national average, or an area where it's a rural area. And you do have to invest, so it's not kind of retained earnings. So sometimes we have people on an E2 and the business does well and they make a lot of money, but that's not sufficient for the purposes of the retained earnings that they have is not sufficient for the purposes of this. You do have to actually have possession and control of the funds and invest the money. In terms of creating jobs, you have to create at least 10 full-time jobs, and you do have to give the government a very detailed business plan. And your investment does have to be linked to job creation. So that's something that you do have to make sure is occurring. And what that does sometimes is it makes it so that you can't, like the example of, for example, you can't buy a business and then when you buy a business, pay the seller the money and the seller takes the money and then you get an EB5 because the government's saying that didn't create any jobs, that just, lined the pocket of the seller. And you do have to create the 10 full-time jobs do have to be for US citizens or green card holders. And you do have quite a bit of time to create those jobs. So, but you do want to make sure that you're documenting that they are actually green card holders or US citizens and that they're full-time. The biggest issue with EB5 is source of funds, because you have to show the government that the money came from a legitimate source. That seems like it's an easy requirement, but it's usually the most difficult aspect of an EB5. And the investment does have to be in equity, so you can't like kind of give someone an amount to invest an amount and then invest an amount and then say that it's a loan and you want the money back. That doesn't work. This is a three-step process where we have an I-526 petition or I-526E petition filed, depending on whether it's a regional center or a direct investment. And then you go again, if the category is current, you can file an I-485 or do consular processing. And then after you have the green card for 2 years, you have to file another petition because it's a conditional green card again, another petition showing that where you can remove the conditions, right? Some other green card options that people move to, and oh, and just with respect to the EB-5, E2 is a big area where people move to it, but lots of other areas, sometimes H-1B, TN, where people are interested in the green card. And typically the E2, when someone's doing E2, it's usually direct investment, but when someone's doing the other categories, they're usually doing a regional center. So other categories where people move to a green card: diversity lottery, you keep your eyes open for that in October, November timeframe, but that's every year we have at least one client that wins that and gets a green card. So, and then there are some humanitarian-based options whether they're U visas or helping the police with the crime, and we definitely see some of those as well. And we do have a humanitarian lawyer that works on those for some of our clients. And then we're always, of course, hoping for some type of immigration reform. So you always have to kind of make sure that you're looking at the timing considerations for visas, because some visas do take, some visas do take a significant amount of time to be processed, and with that, you have to make sure that you're maintaining, underlying status, and and then also sometimes when you file the I-485, it limits your ability to actually to travel. So you just have to make sure that when you're filing the petition that you're able to factor those things in so that you can actually make sure you're maintaining status and that you're comfortable staying in the United States. In terms of green card strategies, you definitely have to look at all the options. We have lots of people we did something recently where we filed an NIW and an EB-5 for the applicant. Luckily, the NIW was approved very quickly without an RFE, which was great. And that was a case where there was an E2, and it was, we were really arguing just economic benefit. And then really planning is key. So that is really all that I had in terms of prepared remarks, and I'm just taking a look to see if there are any questions, and I don't see any. In terms of, thank you very much for joining today. We will again post this on our YouTube channel, and we will send you the guide that has the information related to various different visa types, and we will also send you a link to set up a consultation so that you could get more assistance with any of these. But thank you very much again for joining.